Good morning, and welcome to Kenny and Sam's Employment Law webinar, What You Should Know About the Massachusetts Paid and Family Medical Leave Law. I'm Greg Vandeneykel.
And I'm Brittany Darcy.
And we are both attorneys with Kenny and Sam's, and we thank you very much for joining us this morning. Paid Family Medical Leave Benefits, or PFML as we'll call it all day today, they've been in place for about 2 years. However, the law and the regulations that are in place are complicated, and it's an ever-evolving body of law. And in fact, there's actually not a lot of case law interpreting the statute yet. And so what we wanted to do today was to give you a high-level 30,000-foot refresher and kind of a state of affairs of the PFML benefits in Massachusetts since the law has been passed. So we're not going to cover the nuts and bolts and the details and the minutia of the law, but we're going to try to address some of the major provisions and the issues that we're seeing in our practice today. So with that, we're just going to get started. Brittany, let's start from the beginning of PFML and the cycle. Can you remind employers about their responsibilities with respect to contributions under the law?
Sure. It's important to remember that contributions change annually, and so it's not going to be a consistent rate or amount. For employers who have more than 25 covered workers, the employers are going to be in 2022 contributing the employers and employees will be contributing 0.68% of the payroll. That's going to change to 0.63% of the payroll. And again, that's an employer and employee contribution. Now, employers with less than 25 qualified workers do not have to contribute. They can, but they do not have the same obligation as employers with 25 qualified workers or more. It's also important for employers to remember that they are required to give notice to their qualified workers within 30 days of each rate change. And as I noted, those rates are going to change annually. So it's something for employers to keep in mind each year, that they should be providing updates about what those percentages look like. Another thing to keep in mind is that the percentage is going to shift whether it's a family leave or medical leave.
Okay, so that's something that employers need to be checking their policies.
Checking and updating on an annual basis, yes.
Okay, great. And you mentioned notices to employees about the contribution rates. Are there other notice requirements that employers must give about the law in general?
Yes, and this is another important thing for employers to keep in mind and stay on top of each year. Right now, employers are required to provide notice to covered workers of their rights and their obligations under the law. So employers must display a notice of benefits poster somewhere that's easily visible within the workplace. They are also required to provide written notice of the benefits that are available to their covered workers. The department actually offers a very helpful webpage of resources, and so it would be, helpful for employers to check this website out because it provides a number of resources that they can direct their employees to. The website includes guidelines for benefits, guidelines on how to apply, the health forms that employees must use when they're submitting their request, and also it directs the employees on questions that employers might not know the answers to right off the top of their head, and so it's a great resource to use. The employer needs to provide notice of the rights and obligations to new employees within 30 days of their date of hire. And it's best practice for employees to sign an acknowledgement indicating that they've received this notice so that there's never an issue later.
Yeah, that makes sense. One thing I've seen in my practice is that, particularly with the remote workforce and how to send this notice to new employees or to existing employees about changes, and email seems to be a good way. And again, there's not a lot of case law on this, but it would probably satisfy the spirit of the law for employers to send the notices through some sort of read receipt email and then log and capture those acknowledgments as part of an employee's personnel file to make sure that they're compliant with the statute.
Right. It's an easy and simple solution to a problem that you don't want to deal with later.
Good point.
Greg, can you tell us who qualifies for the benefits that we've been talking about?
Sure. So one thing that's drastically different about PFML as opposed to traditional federal FMLA or even the Massachusetts Earned Sick Time law is that there's no probationary period. Employees are eligible to use the leave or to apply for the leave basically from day one, as long as they're qualified. And an employee is qualified if that employee has earned $5,700 in salary within the 12-month period prior to the date they tried to take leave. So that means that they could have become qualified even if they were with a former employer. Then they can take leave from there. And the law applies to basically every type of employee, full-time, part-time, seasonal, temporary. All employers, regardless of the size of their company, whether you're one employee or 1,000 employees, subject to very few exceptions for municipal employees, public bodies, some agricultural employers. All employers in Massachusetts are going to be subject to this law, and so therefore they need to be planning, and their employees need to know about the benefits. One important thing that's come up, particularly again in the age of remote work, is what do you do with employees who are working remotely? Do they qualify for the leave? And in short, if those employees, let's say you're a Massachusetts company, and those employees are working for you in Texas, for example, but they're performing work that would otherwise be performed in Massachusetts, they're logging on to your Massachusetts systems, those employees are arguably covered by the PFML, and they're going to have to be incorporated within your policies.
And the 5,700 that you mentioned at the start of your explanation, is that consistent or does that change? And if it does change, how often does that change?
Yeah, so that does change. It's up from $5,100 in a prior year. And that's up to the department to decide when they're going to change it. Likely will happen annually because it comports with the changes in the contributions.
And so it's something for employers to be mindful of, again, when
Yes,
they're taking stock of their roster of workers.
Exactly.
It's something that could change and something that they should make note of.
Right, exactly. Because they may be telling somebody that they're not eligible when in fact that employee is.
Okay.
Yeah.
And in discussing these benefits, can you talk a little bit about why an employee might want to apply for the benefits? What qualifies as a reason for the benefits?
Yeah. So there are the statute and the regulations clearly lay out the grounds, the basis for taking the leave, and they're very similar to federal FMLA. But generally speaking, employees can receive 12 weeks of paid leave to care for a family member with a serious health condition. They can receive 12 weeks of paid leave to bond with a child after birth or after an adoption. They can receive 20 weeks of leave to attend to their own serious medical health condition. And then they can receive up to 26 weeks related to military leave for themselves or a family member. What's important with respect to all of these grounds is that there's a lot of definitions that we're not going to go into today, but stuff like serious health condition, who is a family member, that stuff needs to be defined in an employer's policy so that employees are clearly on notice as to whether or not they're eligible to take this type of leave.
One question that commonly comes up, I've seen, is with respect to the parental bonding leave, the 12 weeks. Often you have questions about whether or not pregnancy in and of itself qualifies as a serious medical condition such that you can add to the 12 weeks that you're allotted under this law. Can you talk a little bit about whether that's the case?
Yeah, that's a great question. And again, the perfect lawyer answer, right? It depends. And there's not a lot of fleshed out law on this, but the purpose of the law is to provide specific leave for specific periods of time, and there's a great impact on employers if the leave kind of carries over, 12 weeks here, 12 up to 20 weeks here for a medical condition. The law does have in place that the maximum amount of leave that an employee can take in any 1 year is up to 26 weeks, regardless in aggregate.
Okay.
It's really going to come down to the particular conditions of a pregnant parent, the pregnant mother. Is there actually a doctor's note, a medical certification that says that you have to be on bed rest for a certain period of time before delivery? That's likely going to be a serious medical condition, and then you can take the actual pregnancy bonding leave. But it's going to be a case-by-case scenario.
Okay, so employees should not assume that simply because they are pregnant, they might be able to take additional weeks on top of the 12 weeks of bonding leave.
Correct, yeah.
Can an employee take the benefits over separate periods of time in the course of one benefit year? So can there be intermittent leave?
Yes, so absolutely. So the law does not require employers to provide only continuous leave.
Okay.
There are grounds to take intermittent leave based upon the type of leave that's being requested, because nothing's ever simple, right?
Sure.
So the way it kind of breaks down is that if an employee is taking the PFML related to bonding with a newborn child or an adoption, that decision for intermittent leave is actually up to the employer. The employer and the employee have to agree to an intermittent leave schedule. It's not the employee doesn't just get intermittent leave under the law. What I like to recommend to my clients is be practical about the situation. I treat it almost like a disability or an accommodation request, and go through the interactive process. Have a back and forth, document that, because it's going to lead to better employee goodwill, and it's also going to protect you down the road that you were being reasonable should there be some sort of complaint as to the actions taken if you rightfully decided and reasonably decided to decline the leave. With respect to a serious health condition of the employee, him or herself, or a family member, intermittent leave is permitted, but only if it's supported by a further medical certification explaining why the need is there for intermittent leave and that the employee isn't able to perform the essential functions on a continuous basis.
Okay.
And then intermittent leave is generally available related to military service.
Okay.
The law has very specific rules about the amount of intermittent leave, the periods that it can be taken in, and that's just something that kind of needs to be addressed on a fact-by-fact scenario. But employer policies should outline this information, again, to place employees on notice that there aren't any surprises in the end if a employer does not agree to intermittent leave for a certain reason. At least all of this is laid out.
Right. And so it's important for the employers to be mindful when they're drafting their policies to at least acknowledge that this is the possibility, but maybe not set out in defined terms what it looks like, especially with bonding leave.
Correct. Now that is to say that the employer can provide more benefits than are provided under the leave, and if that's what the employer would like to do, that's great. But if the employer is going to have a policy that is going to attempt to be compliant with PFML, then right, exactly as you laid out is the best practice.
And obviously these benefits are important to so many workers. Are you aware, are there any delays that are implemented by the department when the benefits begin?
Yeah, so this is actually one of the more confusing and complicated parts of PFML is there is a 7-day waiting period.
Okay.
So we'll talk a little bit more about how the application process works. But once an employee is approved for leave, I'll use the example bonding. They get 12. Let's say they want the whole 12 weeks. That employee actually has a 7-day waiting period where that employee does not receive paid leave. So let's say their leave is from January 1st to February 15th. That may not be 12 weeks. I didn't do the math right there.
We're not math.
Right, exactly. But we'll go with that example. So January 1st, their leave starts. January 1st to January 8th is actually unpaid under the law.
And does that unpaid week qualify towards the 12 weeks total?
So yes, and that's what makes it complicated. Because the employee says, oh, but I get 8 paid weeks. Well, actually, you get 7 paid weeks under the law. But what the employee is permitted to do is use PTO or some other paid program from the employer, if that's available, for that week to cover that. The employer cannot require any employee to use PTO to exhaust PTO before using any PFML leave, and it can't require the employee to use PTO during that 1 week waiting period.
But the employee can opt to do so
Certainly.
just to ensure that they're getting paid one way or the other while they're off.
Yeah, and a lot of employees would probably like to do that, obviously, because it's kind of a weird issue in the law, but that's the way they set it up.
Okay.
So I mentioned the application period. So why don't you walk us through the application process? Because I think this is one of those areas that, particularly employees, they seem to blame their employers for how this works out. And why don't you just kind of walk us through there and what employers' obligations are?
Sure. It's important to note that really the employee has a lot of the obligations when they are applying for and essentially seeking these benefits. It's not simply as an employee that you get to go to your employer and say, okay, I'd like to exercise my PFML benefits, so just let me know when I can start and take that time off, or I'm due on July 1st, and so just make sure that you've got those benefits checked off for me because I'll be out of here.
Right.
It's important that an employer understands that to start with, they either need to have a private plan, which can either be it can either be a self-insured plan plan, or it can be a fully insured plan. Or the employer can use the state plan, which I think, generally speaking, is more typical that the employer is paying into the state plan, which relates back to the contributions that we discussed at the start of this discussion. The employee should make sure that they start this application process 30 to 60 days in advance, because it can take some time and there can be some wrinkles. It's also important that the employer is aware that this employee is starting the process, and so the department will send the employer notification when the employee starts the process and again when the employee completes the process. The employer has the opportunity to review the employee's application. It's important to note that the employer does not have any real determining power when it comes to the application, but the review process is important because it gives the employer the opportunity first to make sure that the employee is correctly reporting, or that the employer is noting for the department any instances of paid or unpaid leave that employee has taken in that benefit year, because that is something that the department may factor in when looking at the amount of leave the employee is requesting. It's also important for the employer to report to the department the work patterns and hours of the individual who's seeking the leave. Any concerns of fraud should be noted, although hopefully that doesn't come up often. And after the review, the employer is asked to designate a recommendation for the department. Now, again, this is not determinative, but the department will take it into consideration when reviewing the application that the employee submits. As I noted in the beginning, it's important that the employee makes sure to start this process 30 to 60 days in advance and really take the time to review that website that I mentioned at the start, that hopefully the employers are passing out, whether via email or, if there are notices to employees, to make sure that the employee understands that they need to really do the research and understand what the application process entails to start. The department actually offers a few tips in terms of common issues that they see that result in the rejection of an application. And if you're an employee going through this process, especially if you've got something as serious as medical leave on the horizon, you don't want this to be delayed. A few things that the department have noted is that it's important that the employee provides a clear copy of an identification document. And so anything that is black and white or is faxed is going to be rejected. So something as simple as a black and white ID photo, I'm sure many employees are not carefully paying attention to that, but if that's the reason that your application gets rejected, that can be frustrating. It's also important for employees to note that the certification of the health condition has to be compliant with the form that the department provides. So a doctor's note is not acceptable. Now, hopefully the doctors who are assisting the employee with this process are aware at this point, because the law has now been in place for a couple of years, of what those forms look like, what they require, and how they must be submitted. But it's important for employees to keep in mind that simply having a doctor's note scribble is not going to cut it.
Is it the employer's obligation to provide that department form? Like, should the employer, do you recommend in your practice that employers kind of have copies, know where to find this form?
I think it's important for employers to direct their employees to the website where the department provides the forms, the guidance, because I think there's a fine line as an employer between, you don't want to give advice to your employees if it's the wrong advice. And you don't want to guide them through a process that ultimately results in their application being rejected. Now, to the extent that there is someone designated in the office, which there should be, to help in terms of the administration process here, certainly they can offer advice. But again, I would advise employers to really direct their employees to that website where the guidance and the forms are available.
That makes sense. It's a really good risk mitigation strategy too.
You just have to be careful. You don't want to be the person who's on the hook when your employee calls and says, my application was rejected.
Right, and you told me to do X, Y, or Z.
Exactly. And the final thing to note, and we'll talk about this more toward the end of our discussion, is that employees should not use their PTO while they're receiving paid family medical leave benefits. Oftentimes, because of the disparity in pay, and employees are going to want to have 100% of their pay replaced. That's a decision that the employer can make and a benefit that the employer can provide, but the employee cannot unilaterally go and try to top off the benefits that they're receiving with PTO, because that could result in ultimately the benefits being cut off if the department determines that this employee is doubling up.
Interesting.
So
So you
Can
mentioned
we talk about Top
yeah.
Loss?
So you mentioned Top Loss. So I figured I would use that as a launching pad to the to kind of go into a little bit more detail. So there, as you said, like if an employee is looking for continuous leave, that is, not intermittent leave, the employee cannot collect both PFML and PTO and or use vacation at the same time. Ultimately, or during the same week for the same qualified reason. And it's really that qualifying condition that matters. An employee, and then that's going to be a fact by fact analysis.
Sure.
But at the end of the day, the employee should be using one or the other. And it's important to keep in mind that PFML benefits are not necessarily going to make an employee whole while they're out of the office. It
Right.
obviously depends on that employee's salary, their wages that they earn. But they are, if they're going to use PTO, it's more likely than not going to draw down all of their PFML benefits to zero, which is why you can't really you can't top off. You can't make more than the employee would make on their average weekly rate. Intermittent leave is a little bit different. The employee in the same week, for example, could receive PFML for 2 hours out on a Monday, 4 hours out on a Thursday, and then take PTO for other intermittent or maybe continuous leave. But that's all this stuff needs to be reported to the department, and that's all part of that, to your point, why they need to really plan ahead and do 30, 60 days worth of application filling so they can accurately explain to the department what type of leave they have, what their benefits, what their wages are, so that the right leave is provided. So I think that kind of, it's a complicated issue. It's a fact by fact situation, and it's one thing, again, for employers, the department is supposed to take the lead on this, but the employer information that you provide to the department is going to be critical in determining the appropriate amount of leave.
Okay. So you've sort of touched on this, but can the paid family and medical leave run concurrently with other leave programs?
Yeah, so that's a great question. It's a question I get a lot all the time from my practices, that somebody wants to take PFML, but they've already taken 6 weeks of FMLA, and they also have taken 4 weeks of earned sick time. How does it all work together?
Right.
And they also have my vacation policy. PFML will run concurrently. That means the time will count for PFML, federal FMLA, earned sick time, if they're for the same qualifying reason. So
Okay.
if somebody has knee surgery and they're out for 6 weeks of work, and if they choose PFML, that will also count as FMLA and earn sick time. If an employee has used 6 weeks of FMLA for that knee surgery, and then 3 months down the road they come back, and then 2 months after that they want to go out again for the same knee, they need rehab or something, but they want PFML. Well, now they're not starting from zero; they're starting from 6 weeks
Sure.
of leave that's left. Interestingly, depending on your employer policy, PFML can also run concurrently with paid leave policies, your vacation policies. This kind of prevents somebody from taking paternal leave, paternity leave, and for like 12 weeks of paid PFML, and then wanting to be out another 6 or 8 weeks for paid vacation. If your policy notifies the employee that PFML will run concurrent with your PTO, that's it. Then you can't kind of double count and add and stack the leave, which is really helpful, particularly like small businesses
Sure.
who can't have people out of the office for 20 weeks, 30 weeks at a time.
Right.
Which makes sense.
Right. And so it sounds like it's important to just make sure that your handbook or the notices that you're providing to your employees just clearly lay out some of these discrepancies and the rules surrounding stacking leave or topping up.
Absolutely. Yeah, absolutely.
And I think one important point to touch on here as we're getting close to the end of this discussion is talking a little bit about the protections in place for the employees when they exercise their rights under the Massachusetts Paid Family Leave and Medical Act. And so it's important for employers to keep in mind that there's pretty strict rules surrounding retaliation.
Okay.
There is a 6-month mark that employers should keep in mind. The employers are prohibited from interfering with an employee's rights or retaliating against an employee who exercises their rights under this PFML. And there's a rebuttable presumption that if the employer takes some sort of adverse action in that 6-month period,
That's after the leave.
the leave, yes. That if there is an adverse action, there's the rebuttable presumption that the employer is retaliating against the employee. Now, that doesn't mean that any adverse action taken in 6 months following the employee's leave is absolutely going to be determined retaliation. And in fact, it's all the more reason for employers to start at the beginning of an employee's
Yeah.
employment, not just when they're starting to talk about leave, of making sure you're notifying the employees of their rights and obligations, keeping records of any issues that arise with an employee so that if there are any sort of adverse actions that need to be taken in that 6-month period later after the employee returns, an employer has the ability to say that the action was legitimate.
Yeah.
Now, on the flip side, the rebuttable presumption exists for a reason. It's intended to protect employees who return after what some might say is a long period of time. The employee has the right to return to a position that has the same seniority, status, pay, all of the sort of pieces of the employment that they enjoyed before they left. They get to come back to that same position.
Yeah.
And it's important for employers to be aware of the 6-month period because it can feel like a long time, and that doesn't also mean that it's 6 months and 1 day. If you've got problems with someone, you're in the clear if you take an adverse action.
Yeah.
So it's one of those dicey, fact-specific areas that all the more reason to seek out legal counsel in those tricky situations. There's no right answer, but often finding legal help is the best way forward.
I think it's amazing to me that we've probably taken 25, 30 minutes at this point, and we probably have barely cracked open what
Barely.
is PFML. And,
Right.
like I said, this was supposed to be a high-level overview because this is a prevalent part of Massachusetts employers' lives, and it's going to be here for a long time, and it's going to continually be amending. So what we want to leave you with is, be aware of the law, update your policies, keep your employees notified. Know that this law changes on an
Right.
annual basis, and this is not only just the contributions and the wage rates that can be paid, but also the substance of the law. And so, as you said, consult with counsel before making any rash decisions or related to employee discipline or employee replacement during this types of leave, because there are some critical consequences that could result from a failure to comply with PFML, and it's going to be with us for a while. So.
Yes, it will.
So Brittany and I both thank you for taking the time out of your busy schedules to participate, to watch us. Please feel free to contact us with any questions should they come up. And we both invite you to join us for the Kenny and Sam's next employment webinar, which will be on December 14th. And it'll concern leaves of absences, the do's and don'ts. And if you've missed any of our prior seminars, please know that they're available on our webpage. And we hope that you find this helpful. Thank you very much.
Thank you.